I think that's just like a general rule of thumb. If you want to be able to claim to the seller, hey, this is not what you sold me, you've got to be precise as to what they're selling you. The title search date, and I talk about this quite often, the title search date or requisition date, as lawyers will call it, is the day that the liability switches from the seller to the buyer. So it's a more important date than the closing date. There's a difference between beneficial ownership and registered ownership. The beneficial ownership transfers, but the registered ownership does not. Don't draft down contracts, don't take them on the internet, just don't. It's not worth it. The majority of the time, large legal issues happen because people try to save a couple $1,000 in legal fees by not getting a properly drafted contract and then end up in a monstrous mess later. Oftentimes people think it's a will that's attached to a corporation, and it's not. A will is for individuals.
Hello, everyone. Welcome to another episode of Real Estate Conversations with Harsh, a podcast for investors by investors. Today, we will be discussing law and some critical items that should not be missed when transacting in real estate. Today, we have a 12-year veteran practicing law and running her firm, Cardinal Law. Milena specializes in solving complex real estate, corporate, and estate planning puzzles by providing innovative and simplified setups and transactions through a holistic and collaborative approach. We want to welcome Milena Cardinal from Cardinal Law, a sought-after speaker at real estate events, associations, and other meetings. And she is very, very knowledgeable and entertaining and applies her unique approach to various legal topics. Milena, welcome to the show.
Harsh, thank you so much. That was lovely. Making me blush a little bit.
All right. So we'd like to know how you got into real estate, and now you're a lawyer, practicing lawyer for 12 years, right? So we'd like to know your story. How did you get started? What were you doing before this? If you were doing anything, or if this is your first thing that like after school, you just went into law and then law school and then just went into a lawyer. So let us enlighten us with your story.
Well, I started out, I was a lawyer first before I became an investor. And I very much had a brick and mortar type practice, small town law firm, very much like Main Street kind of law firm. I was practicing a little bit of everything. And the reason I started my own practice right as I finished. So as soon as I finished law school, I did my articling, and then I started my own practice right away. Largely because we had moved a lot. I went to law school in Sherbrooke, and then I went to Queens, and I moved a lot for the first few years. And I was a single mom at the time. And my daughter, when we moved to Cornwall, she was like 9 years old. And for the first time, when we moved from Kingston to Cornwall, she really struggled with the move. And before that, she was always happy to discover new places and excited. But when we moved to Cornwall, it was tougher. She was older, friends were more important, right? She was trying to build those deep friendships and having a bit of a hard time with us moving all the time. So when we moved to Cornwall, I told her that unless I couldn't feed her, we would stay in Cornwall. And so even though it wasn't my plan, I did fall in love with the area, and I do love living here. And so I decided to stay in Cornwall, but there weren't any job openings for a brand new lawyer with very little experience. So I was like, you know what, I was going to start my own practice and do my own thing. And I did. And so that's kind of like how Cardinal Law got started. And so I had
this was 12 years ago?
That was 12 years ago. Yep.
Wow.
And I had very much a brick and mortar type practice, and not the at the level we're at now, of course. And at one point I met my husband about 8 years ago. I met my husband, and he's American. So when he came to Canada, he wasn't allowed to work for the first 2 years while he awaited his permanent residency. And Ryan is someone who can barely sit still for a movie, never mind sit still for 2 years waiting for his permanent residency. So while he wasn't allowed to work, he was allowed to invest. And I had clients who were real estate investors, and they had become good friends of mine and then good friends of ours. And they were talking about the real estate investments, and Ryan got really curious. His background's in architecture, so he knew a lot about buildings, and so he got really curious, and an opportunity sort of fell on my lap. And so we jumped in with a small flip and kind of caught the bug. And eventually Ryan got a position in architecture for a number of years, and actually stopped working 3 years ago to focus on our portfolio as it had grown to that size that needed his attention. And so that's kind of like where we kind of became investors by happenstance, right? And then as we were building our portfolio, we were new investors. We were meeting other investors locally in Cornwall, small like landlord groups and whatnot. And a few investors started to say that they would really love to work with a lawyer who knew about real estate investing, who was an investor herself, because that's what I was, right? So even though I wasn't real estate investor focused, I sort of like started to have a clientele of real estate investors because I was one myself. And so, and I would get so passionate and so excited about working these deals with investors, because it allows me to get really creative and to find different solutions. And it's not as streamlined as buying a home, right? So then when at one point I was talking to my coach, and she said, you never get as excited as when you talk about real estate investor, your real estate investor clients. Like, you should become a real estate investor focused lawyer. And I was like, is that a thing? And she's like, well, it's a thing if you make it a thing. So this was about, I would say, 3 to 4 years ago that I made that jump. And I was like, you know what, I'm going to start shifting to focus on real estate investors. And we were very innovative. We became virtual. We started to offer services throughout Ontario. And then when the pandemic hit, we were able to really take that to a whole nother level by becoming 100% paperless and virtual. And and now half of my team works remotely, and I love what I do. If all we were as real estate investors, I tell my husband sometimes, like, we can't feed enough deals for me to like have enough deals that I have my hand in. So as a lawyer, I get to have my hand in so many deals and do use so many creative strategies in so many transactions. So it feeds my soul.
Absolutely. I couldn't agree more. Okay, so that's a fascinating story. Like, it's really great, and I'm glad that you shared it here in full, and that explains how and why you became a real estate investor, and while doing your law practice. And Cardinal Law, like it's a well-known name in the industry, especially in the lawyer industry. So there's no doubt about it. And you're doing great. You're doing great.
Oh, thank you. I appreciate that.
Yeah. Okay. So we'd like to focus now from a lawyer's perspective on this episode, where we'd like to talk about some important clauses that normally you have seen new real estate investors, or sometimes even more sophisticated investors, miss, right? And when they're doing offers, like a couple of clauses that should be there, that are that protect the investors as a buyer.
So I think for me, one of the most important ones, and I practice in Ontario solely, right? So I'm speaking specifically about the Ontario Ora Form of Agreement of Purchase and Sale, the section that talks about title search and the type of property. So often an offer will land on my lap after being, it's unconditional at this point, right? So it's not amendable anymore. And so often it'll say that the use of the property is multifamily, or a multi-unit, or a multi-commercial / residential, but it won't say the number of units. So I have faced multiple times, especially in the last few years, scenarios where we get an offer and the client, the buyer, tells us this is an 8-unit building, or this is a 12-unit building. And then we do a search at the city, and no, it's not an 8-unit building, it's a 6-unit building. And then when we go to try to tell the seller, hey, your client sold us an 8-unit building, they say, we sold you a multifamily property. So it's extremely important that buyers be very precise in that section, in that spot, where it says the current use of the property. Be as detailed as you can. 8-unit multifamily residential property. right?
Oh, okay.
Not even just
Are you
8
talking about the
units.
current use section?
Yes.
Okay.
Sorry? You asked
The current use section in the Ora Form, right?
yes,
Where
where it
you
says
specify
like, I think it's in the title search section. It says something like that it gives you until a certain date and time to advise of the seller that you cannot continue to use the property in its current state, and its current use can be continued. So that's that section.
Yeah,
So
the current use section, it's below the title search.
Yes,
Current
right
use
below the
section,
title
yeah.
search date.
Yes.
Mhm.
Yes.
So just be
Use
precise. And
section.
I would bet this would apply to other provinces as well. I don't know what the contracts look like in other provinces, but I think that's just like a general rule of thumb. If you want to be able to claim to the seller, hey, this is not what you sold me, you've got to be precise as to what they're selling you. And if they're selling you an 8-unit fully residential building, you've got to say that. And if they're selling you a 6 units residential, 2 units commercial, be precise and put that, right? You can be as precise as you want. And you can, even if you're lacking space, just put as set out in Schedule A. And then in Schedule A, add a clause that says the current use of the property is blah, 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 right? And just be very precise. So that's number one.
Okay. And so coming from that, a question. So when we're doing offers, right, and we mention that, okay, it's a multi-unit residential, but sometimes we have seen that these are legal non-conforming buildings as well, especially the smaller ones, like 5 to 6 units. What they do is they'll take a 5-plex and then slash up 2 units and make it into a 7, right? So, but those 2 units are actually non-conforming. So mention like a multi-unit 7-unit non-conforming, or multi-5-unit with 2 non-conforming. How would you mention that in the current use section?
Well, you're basically, if you say that, you're basically saying, I'm agreeing that 2 of these units are illegal, right? And I'm accepting that. So it depends on what you're accepting. If what you're saying is you want a fully legal building, it's very different than not. So what I would say is that section specifically says that you're able to search to verify that the current use of the building can be continued. So legally continued, which means that if you have a building, and there's a difference between legal non-conforming and non-conforming, because if it's legal non-conforming, basically it's what that means is that even though this should be a duplex, it was a triplex before the bylaw came into play, so it's grandfathered in. So when we talk about legal non-conforming, we're talking about that it's grandfathered in. Otherwise, when we're talking about non-conforming, we're saying it's illegal. It's an illegal unit. And so sometimes you're okay with that. And then you can get creative in your offer when you say, I'm going to take the risk. And when the city comes and says, you must get permits for these units, I'll deal with it because I've got the experience and I can deal with that. Yes. You know, so some people are okay with that, but you have to go in fully aware. And as a seller, if you're selling something like that and your buyer is fully aware, just add it to the contract. Say, the parties acknowledge that there are 2 units that are not legal, right? That are non-conforming with the building code, or haven't obtained permits with, or whatever it is, the wording that you want to use. And of course, a lawyer can help you draft that properly, but you have to be precise in the contract as to what the agreement is.
Yes. Okay. But in legal non-conforming, we can just say multi-unit legal non-conforming 7-unit.
I would just say 7-unit residential multifamily. Okay. Because if it's legal non-conforming, it's legal, right? It's the same thing. Mm-hmm.
Okay.
It's just legal because it was grandfathered in instead of legal because the city stamped its approval on it.
Oh, okay. Okay, perfect. Okay, the second, so one more. Yeah. We'd like 2. We'd like more, but we have so much to discuss.
I can give you quite a few. Let me give you 2 more. So one, the title search date, and I talk about this quite often, the title search date or requisition date, as lawyers will call it, is the day that the liability switches from the seller to the buyer. So it's a more important date than the closing date. And in real estate investor contracts, usually there's extensions. It is so common, right, that a deal gets extended. And a lot of the time people forget to change the title search date when they change the purchase date, the closing date. So say, for instance, you have a transaction that's closing on February 1st. right? And you've got the title search date set for January 10th. And then, January 1st comes along, you're like, we'll never close on February 1st. We need to extend by another month. So you extend the closing date to March 1st. And then something else happens, and then you extend the closing date to April 1st. And then you send the contract to your lawyer on March 1st. And the title search date is still set to January 10th, which means that the liability has now passed to the buyer. There are certain things, and I don't want to go too far into the legalese because I don't want to lose your audience, but there are certain things that no matter what, the seller will have to rectify or fix or pay out. It's not like the buyer is now obligated to assume the mortgages of the seller, things like that. But there are a lot of other title issues that can be extremely costly that the buyer may end up having to assume because it's too late to now tell the seller, fix it, or I'm not buying this property. So super important to understand that title search date is the most important date, and making sure that if you move your closing date, you also move that date.
Yes. Okay. Perfect.
Yeah.
And what's the next one?
Last one, I mean, there's, like I said, I probably have 100 ideas, but last one I'll mention is if you want your contract to be assumable, meaning that you want to be able to assign it to your corporation or to a third party, there is a way to draft a clause, depending on if you're a buyer or seller. Of course, I'll draft it differently, but if you're a buyer, ideally you draft the full clause that states not only that you can assign the contract to your corp, but that upon the assignment, you are released from all liability. This will protect you from personal liability if the deal doesn't close, and it would also protect you if you're assigning it to a third party that's not your own company, if they can't close. So then the liability would pass to them. So just a little.
Nice.
Yeah.
Yeah. Normally in the assignment clause, yes, I do add that. Yes, the buyer has the full authority to assign it. And if it is assigned, then the buyer is really not liable for this. The language, like I don't remember the exact language, but yes, that wording is there. But sometimes, yes, I have seen that wording is not there. I know what you're stating. Good. Okay. All right. Now, I know you specialize in certain creative strategies, especially in the times we are in now, right? Because we have seen a lot of agreement for sale. We're seeing VTBs are back. That's the vendor takebacks. And now more of the real estate deals are getting done as joint ventures or shareholders agreement. So what's your thought about on those creative strategies? Because you specialize in these.
Mm-hmm. Well, definitely the market having shifted to more of it's becoming more of a buyer's market now, where you have sellers that are desperate to sell. Buyers are having a harder time with the mortgages, the mortgage rates, the way they are. The qualification is harder on mortgages. So we have to get really creative to find ways to not only finance the deal, but actually make the deal cash flow, right? So I'm seeing a lot of these strategic creative strategies being implemented now that wouldn't have been maybe 2 years ago, when the seller was like, hey, if you're not just buying it cash and closing in a week, I'm not selling it to you. I'm going to sell it to the next person because there's a line of 20 people waiting to buy this property. So it's a very, very different market now. And so these strategies it's super exciting because I get to use them again. But I would say that right now, the one that I'm seeing that's the most popular is the agreement for sale. It's coming up a lot in a lot of conversations. I'm starting to implement a few of them because what an agreement for sale does is it actually transfers the ownership of the building to the buyer. But because the seller remains on title as trustee for the buyer gets the benefit of the seller's mortgage, which a lot of the time we're talking about a mortgage at say like 2.5% interest, and there's like 3 years remaining on the mortgage, right? So if a buyer buys a property now at like maybe 60% of the value is a mortgage that the seller has, and they make an arrangement that the other 40% is going to be paid, or say 5% is paid up front, and the other 40% is going to be paid at the end of that 3-year term that's remaining for the seller. It can be such a great strategy to put in place because, one, the seller is able to sell and the full ownership transfers to the buyer. What let me take a quick step back here. There's a difference between beneficial ownership and registered ownership. The beneficial ownership transfers, but the registered ownership does not. So imagine a JV, and this is often the example I give because JVs are a concept that most real estate investors understand pretty early on. So if you have a JV partnership and you have a qualifying partner, that qualifying partner goes on title to the property. Even if they only own 10% of the project through the JV agreement, they will be the only ones on title. But as the only registered owner, they're not the only beneficial owner. Their beneficial ownership is to all of the JV partners. So it's kind of the same thing, except the seller in that case is not a beneficial owner at all anymore. Once the transaction goes through, the buyer becomes the beneficial owner and the seller remains as trustee. This is a concept, by the way, that's very popular in the States. It's called subject to in the States. And it's also more popular in Alberta, but it's really starting to make its way in Ontario. We have the added challenge of the land transfer tax in Ontario that they don't have in Alberta, but we find ways to make that work as well. And really, really great tool and strategy. So, yeah.
Oh, wow. So I wanted to understand what's the difference between mortgage assumption and the agreement for sale. Seems to be like there's a very thin line between them, right? Because in assumption, you're assuming the same mortgage that the seller has. But I think the covenants may differ because right now the covenants are with the of the seller, right? And when you assume the mortgage, you qualify and your covenants get as a security towards the mortgage, right? So is that the only difference, or what's the difference between the two?
In an agreement for sale, really, the buyer is assuming the seller's mortgage. The only difference is that the bank is not involved in that process. The bank, as far as the bank is concerned, the mortgage remains in the name of the seller. And it's the buyer is assuming the mortgage as far as the seller is concerned. But when you're doing a straight purchase with an assignment of the existing mortgage, the buyer goes to the bank, qualifies for that mortgage, and then the mortgage is transferred from the name of the seller to the name of the buyer. But it's actually extremely rare to get to qualify for an assumption on any property that's not with a commercial mortgage in a very large multifamily. So you're very rarely going to see an assumption of a mortgage, a straight assumption in a fourplex, for instance. But now it's the time to buy a fourplex with an agreement for sale because the seller will be able to sell it at a higher price, and the buyer is going to assume a mortgage at a really low rate, and still the deal will still cash flow.
Yes, but nowadays we are, as realtors, like we on the commercial side, like, and I'm talking about small commercial multifamilies, like 5-6 units, or even like these are residential but multifamily. We are seeing that people or the sellers are asking if the buyer wants to assume the mortgage, because what we are seeing is that they bought the property, they refied, and they're highly leveraged, and now they want someone else to assume that highly leveraged mortgage if someone can, so they'll sell it. So
but oftentimes, but then you've got to get the bank to agree. And why would the bank agree when they know full well that if they sell it outright, now they're going to be able to sell a mortgage at someone at 7% instead of 2.5%, what is currently there? So,
well, sometimes it happens with the banks that maybe the banks are allowing, that's why they are saying, and that's why we are seeing it in the market. But it's rare on the residential side. But yeah, on the commercial side, it's pretty common, like 7 and 10 units and above. It's very, very common nowadays. And similar to now moving to the VTBs, right? What would you see? Like I was reviewing an offer clause right now. And the buyer's lawyer, or sorry, the seller's lawyer, they actually very smartly mentioned that it's at 4%, but they also mentioned that, the VTB will be at Bank of Montreal's prime rate and at least 4%. So, which eventually means that whatever the prime rate of BMO is, they'll just have to pay that kind of interest. Plus, and if it goes down, they'll not take any payments less than 4%.
Right.
And then on top of that, they also had something in there which said, and monthly, like I think it's compounding monthly, which is really bad because it'll compound like 12 times a year.
It's more expensive to the borrower for sure to have it compounded monthly rather than annually or semi-annually. Yeah.
Yes.
Or
absolutely.
you could be CRA and compounded daily. That's the worst.
Yeah, that'll like compound 365 days. Wow.
Yeah.
The seller will really make money.
That turns 7% into 10% right there.
Yes, absolutely. Yeah. Okay, so coming back to that vendor takebacks, like any important things that you'd like to our viewers and listeners to know about?
I love vendor takebacks because you can get so creative and they so depend on the transaction. Because if the seller's really, really hungry to sell, I've seen people convince sellers to give them a vendor takeback at like 0% for 3 years because the seller's like, I'll do anything. I need to sell this property. At least if you can give me a purchase price that makes sense, I'll let you pay me back in full, like, with no interest in 3 years. That's fine. But I've also seen circumstances where a seller will say, well, I'll give you a vendor take back because I know it's going to allow you to get into the market and start, as a real estate investor, but I'm going to give it to you at 12% or whatever. Right. So it's like there's drastic differences from one vendor take back to another. I've even seen cases where specifically in the contract, it says that the buyer will pay the legal fees of the seller for the vendor take back. So oftentimes what I recommend in that case is like, if you're willing to pay the legal fees of the seller, just cap them. Just say up to $500, up to $1,000, because you don't want to be in a position where, the bill is like 3 times what you expected. So, I've seen like drastic differences from one file to the other. A VTB is sky's the limit. And I've also seen VTBs, by the way, that are not registered as a mortgage. VTBs on a promissory note. So I've seen that as well, especially if the seller's really that hungry. You can make it a promissory note that's registerable in the event of default. So oftentimes this is the way the deal works, because otherwise the bank will not give you a mortgage if there's this VTB registered on title. Yes,
and especially on the second position, they'll not do it. Yes. Oh, wow.
I've even seen VTBs registered on another property, right? Like you give security on an existing property that you already own. So that it doesn't impede your ability to get a mortgage on this purchase. So sky's the limit, guys. Like you just got to get creative.
Yes, absolutely. And
find someone to brainstorm about it, right? Someone to bounce ideas off of.
Yes, and I completely agree. Nowadays, in the VTB part, normally we have seen buyers pay the lawyer fee for both the sides, for the buyer as well as the sellers. But that's a nice advice, that cap the seller onto like up to $1,000, up to $1,200, or maybe even better, use your own lawyer for both sides, right? And then you have control over what the cost is.
You have to be careful with that though, because there are strict rules with the Law Society as to what one lawyer or one law firm can do. Because if it's
I'm saying like 2 different law firms.
Yeah. Oh, I see what you mean. Yes.
2 different law firms. Okay. We'd like to talk about joint ventures or shareholders agreement. Key things that you advise from a lawyer's perspective that everyone should keep in mind, because I've seen people and investors, especially the new ones, they get into trouble. If something goes south, then it's a legal mess. And because the JV agreement or the shareholders agreement was not written right, in the first place, because a new investor always tries to save money where they can, especially on the lawyer side, which is not really a great idea, but they still do, and sometimes they end up in trouble. So your thoughts about that?
Friends don't let friends draft their own contracts. That's my thoughts on this.
Okay.
Don't draft your own contracts. Don't draft your own contracts. Don't take them on the internet. Just don't. It's not worth it. The majority of the time, large legal issues happen because people try to save a couple $1,000 in legal fees by not getting a properly drafted contract, and then end up in a monstrous mess later. So I definitely recommend if you're going to be a real estate investor, if you're going to be like serious about, taking care of your investors, taking care of your like different parties' interests, make sure that you get properly drafted contracts. And oftentimes, I should say too, oftentimes the issue is not because one person is trying to or one party is trying to circumvent what was agreed upon. The issue is that there was a misunderstanding of what was agreed upon. Don't get me wrong. Sometimes some investors, it's not great. They don't take care of other people's money. They don't respect their what they said they were going to do. And I do see a lot of litigation be sparked by things like that. But most of the time, the issues that come between partners are just misunderstandings. And you can avoid a lot of misunderstanding by having a properly drafted contract. Yeah.
Yes.
Which is actually the same reason I believe in prenups. It's not because you want to, always look at your partner or your spouse with suspicion. It's not that. It's because it forces you to have the hard conversations up front before you get married or before you enter into a partnership, right?
Absolutely.
Yeah. So I think what's important to have in either a joint venture agreement or a shareholder agreement is an exit strategy. And I'm not talking about the exit strategy of the project. I actually think that's less important, because the exit strategy of the project, while you should have a really good idea of what that is, I don't think you can bind yourself to it because there's so many unknowables, right? You can't say in a JV agreement, we will refinance on June 1st, 2025. Like, you don't know that you'll be able to do it that strictly. So we have to be cautious of the wording we use to not bind people so tightly into what the project is going to be. So we use language that's generic, that I outlines what the understanding is. But what, in my opinion, needs to be really, really strict language is what happens if someone wants to be bought out. Can they sell their share? What happens if somebody dies? Is there an automatic buyout? Right?
Yeah.
How are we going to finance this buyout if somebody dies, especially when you're talking about shareholders?
Absolutely.
Right? So if you have shareholders, like, you can be in one hell of a mess if you have an automatic buyout on death that's payable within 30 days. Well, good luck refinancing that to buy out the estate of your deceased partner, right? So important to really think about those things. Like, do we need life insurance? Do we need to buy life insurance on the partners? Do we need to give like a long time to pay it so that we don't end up having to just sell everything we've built together, So all of these things are extremely important.
No, yes, and I completely agree. That's a very, very valuable point about the insurance, and because you never know. And I know somebody who's one of their partners, like one of the investors with him, they died, and so he was good. He called in the home, and then he told the wife that, "Don't worry, we'll figure things out. Just get these things done and we'll figure things out." And he did return the investment after like 6 months, but eventually after 6 months they said that, okay, we don't need it, keep it, we'll take it afterwards, like whenever the maturity is. So that ended up good, but not all the situations will end up like that, right?
So, and I've seen horror stories, and I've seen positive stories like that. Yes. I had a matter once, and it was two partners who were in the construction industry, and when one of them died, they were very close friends. The two partners and their families were very close, and when one of them passed away, because they had a proper shareholder agreement in place, they had life insurance on both the partners, they had all of this stuff very well laid out. So when one of them passed away, even though it was an automatic buyout, the life insurance came in, paid into the corporation, into what we call the CDA, I believe, capital dividend account. Yes, which means that then you can take the money out of the corporation tax free. So the widow of the partner who passed away got the payout that was expected, and it didn't deplete any of the assets of the business. And the partner there was even left over enough to pay all the legal fees, which were actually not that much because it was so simple. And also he had enough money left over to find a new employee to step in and into that role. So it was a lot to deal with the partner that remained, because he needed to figure out how to run this business while grieving, with Well, the two wives even were having such a hard time, like they had to deal with all that. The one thing they did not have to worry about was the buyout and having enough money and not having to deplete the business. So I mean, I've seen like really well set up things that were really, really well set up like that. And I've seen horror stories when it's just the opposite. And it's just not worth it. It's not worth putting your family through that, for like the couple $1,000 it's going to cost you to set it up. So.
Yes, absolutely. No, I understand that completely. Yes.
Yeah.
Okay. And now that insurance part and all this talk now brings me to the topic of will, right? Yes. What we have seen or what we like to know about is the corporate will, or which is also known as the secondary will. Your opinion, your thoughts, what's there about that?
So I love that we're bringing up this topic because I actually have this conversation like every other day with real estate investors, because there's often a misunderstanding as to what that is. So oftentimes people think it's a will that's attached to a corporation, and it's not. A will is for individuals, right? So what the law says is if you pass away and you've got a whole bunch of assets, and one of those assets need to be probated. And I don't want to get too technical, but the gist of it is to probate means to obtain from the courts a certificate of appointment of estate trustee, which is a document that allows you to act on behalf of the estate. When you apply to get this certificate from the court, you have to pay probate tax, and you have to pay that probate tax on the estimated value of the entire estate, which means that if you only have one asset that you need to probate, you still need to pay that tax on the whole value. It's usually between 1 and 1.5% of the value of the estate. So say, for instance, someone has a house worth $500,000 and they have investments of $300,000. Yes. And then they have a corporation with $1 million, say, of equity in buildings that are owned by this corporation. And say they have a boat worth $50,000. The total value of their estate, making you do math now, total value of the estate is $1.85 million. When you go to probate, they're going to have to pay probate tax on $1.85 million. Whether they don't have a will or whether they only have one will, they will have to do that. When you have a primary will and a secondary will, it's almost like it creates a second bucket, right? And sometimes we call that a corporate will. To me, it's a misnomer. It's a secondary will is the proper term. When you have that, you're saying, you're on the document, on the will, it'll say, this will cover all shares I own in private corporations, as well as anything else that my estate trustees deem a good idea to put in the second bucket. So what your trustee is going to do in the example that I gave is they're going to say, the house will go in the primary bucket because it has to be probated. The investments will go in the primary bucket because they have to be probated, assuming they do. So there's going to be 800,000 over here. The shares of the corporation don't need to be probated. They go in here. And the boat doesn't need to be probated. It goes in here. This is just dealt with separate. It doesn't get dealt with the probate. So now you're left having to pay tax on 800,000. I just saved your family $15,000 and cost you $200 to do it. Do it. Get a secondary will. It's a no-brainer. The second you become a real estate investor, if you start doing private mortgages, if you have a corporation, any of those things happen, get your secondary will done. The one thing, one will cancel out the other unless you do them both at the same time. So you have to redo your primary will at the same time to get your secondary will done. So super important. Get your secondary will done as soon as you have like a certain number of assets with enough of value in it, or the moment you get a corporation, just get it done.
Yes. Wow. That's something, and that's an eye opener. I know many people don't know about this, about the secondary bucket. So that's a very valuable point. Okay. Now coming to, I'd like to ask about the GPLP structures. We're discussing everything around the investor framework. And now we would like to discuss the GPLP structure, where the general partner, it's similar to a shareholders agreement, but one is a limited, one is a general partner, which is the managing partner. So if you can give us a quick overview where if you see like if you're explaining it to somebody who is very new to real estate investing, or maybe an 18 or 20-year-old kid, if you want to explain it to them, how would you do that in like less than 5 minutes?
For sure. Well, what I can start by saying is that a GPLP structure is GPLP is not for the faint of heart, and it's not for small deals. One, because it's extremely expensive to set up. Like you're probably looking at a starting fee of like $20,000 to get set up. So it's really valuable when you're looking at doing a large project and you're going to get financing in stages, or you're going to capital raise in stages. So if you have a project that requires, say, $2 million of raises, and you want to raise it in little bits, like 50,000 here, 100,000 there, and you want to do that a little bit at a time, right? As your project progresses, a GPLP can be a fantastic tool. But again, it's not for, you're not going to use a GPLP structure, at least not in Canada. It's something different in the States. It's not quite the same. And I don't really understand it, so I can't speak to the States. But in Canada, when you're using a GPLP structure, it's not ideal to use that for a smaller project. Typically, you're better off looking at a JV agreement or just a corporation with a shareholder agreement. But a GPLP structure, what it does is it separates the liability from and shields all of what we call the LPs, the limited partners, who are basically your financing partners, all of your investors. It shields them from liability. But there's a couple of criteria for that. Number one, they are shielded from liability as long as they have nothing to do with the GP. So the GP has to be a complete different entity that has nothing to do with the LPs. And that means that if you're doing your own project and you're using a GPLP structure, but you also want to finance, say, 100,000, if you want that 100,000 protected, you need to invest it through a different company into the LP, because otherwise you're muddying the waters and you can attract liability to the LP that would normally just be on the shoulders of the GP. But the gist of it is that the GP over here will manage the project. They'll manage the project. They usually find the project, they qualify it, they get everything done for the project. And then the LPs over here, they just bring money. And their only risk in the project is to lose the money that they've put in. The other thing is, very important. When you're using a GPLP structure, keep in mind, you can only use accredited investors, which limits your pool of investors, right, that can invest in your project. So accredited or exempt, which means just friends, family, and close associates. And nobody has 100 close associates. So just keep that in mind when you're doing that. And there's a lot of due diligence that goes into it that I've seen people not understand. So make sure that you work with a lawyer that really knows what those requirements are, and that you fully understand that if you don't want to get in trouble with the SEC, because if that happens, you're not buying real estate anymore. So avoid that.
No, that's a fair point. And yes, well, thank you very much for that. Any other point that you'd like to add on any of the structures, or what you're seeing right now in the market? Like, are you seeing more of JVs? Are you seeing more of a corp shareholders agreement, or are you seeing now GPLP? And also, before we get into that, I'd like to ask, for a GPLP, like you said, for large deals, so is there a deal size you'd recommend that after, if you're crossing this number, go with the GPLP, it's worth it?
That's a really good question. It's really not just this. There's so many factors, right? And if anybody's heard me in my talk on the what we call the puzzle wheel, with all the different factors that I take into consideration when determining for a client what's the best structure for a deal or the best corporate structure for their business, I look at liability protection, tax minimization, financeability, attractiveness to investors, long-term goals, and cost. So those are really the 6 pillars of the different factors. There's so many different elements that go into deciding this. So for example, if someone has a $30 million deal and they're raising $10 million, but they're raising it from 2 partners, I might say just incorporate. You're fine doing a corporation. But if you're doing maybe a smaller project and you're raising maybe 1.5 million, but you're like, I've got to do this in little bits, and it's over time, and I'm going to need, 100 investors, or maybe that's an exaggerated number, but then I'll say, yes, a GPLP is what's appropriate here. So it really depends on your project. It's so specific.
Okay. So I would say, like, I don't know if it's a fair statement to make, where if you have a larger pool of investors with small amount of money, then GPLP makes sense. But the deal size should also be there, right? It should not be that you're only raising 500,000 and now you want 100 investors in there. So that'll not, like, it'll be very difficult to manage. Yeah. Right.
And the other thing too is you can combine these strategies. I've got a client I'm working with right now, and I have their permission to say this, but what they're going to do is, because they're doing phase 1 of the project, and then they don't know if their exit strategy will be to sell the project or to move on to phase 2, which will involve building. They don't know if they will need the GPLP. So they're going to start out with a JV and then transition to a GPLP structure later. So you can combine these strategies based on each particular project.
Oh, okay.
But yes, what you're saying is true. More investors would hint at a GPLP rather than a JV. Yes. But the size of the project will matter. The profitability of the project will matter. There's multiple different factors here.
Okay, perfect. All right. And well, that's about it. Like, I gained so much knowledge today from you. Like, it's always good to talk to lawyers, and especially who are real estate investor focused lawyers and investors themselves. It really helps, right? It really, really helps. So one last question. Where can people find you? Is it cardinallaw.com and they just book a call with you, or Instagram or anything? I mean, we'll be posting your social handles when we release the episode, but what's the quickest way for everyone to, because sometimes people would not read and they'll just listen. So we'd like to, you to, tell them that where they can find you the most.
Our website is cardinallaw.ca, not .com,
yes.
.ca.
Sorry, yes.
So that's one way. And there's a form on there that they can fill out if they want to request an appointment or, or to contact them. And otherwise, sometimes people reach out to me on Facebook, although that tends to be a little slower for me to respond, but I try. And if you reach out to me through our website, my assistant June is really quick at responding. So that's probably the best way.
Perfect. There, people and viewers and listeners, there it is. We had Milena Cardinal and from Cardinal Law today, and there were some really golden nuggets from her. And I was surprised about the secondary bill myself. So, to be honest.
Are you saying you need to book an appointment with me, Harsh?
Yes. Pretty sure we need to book an appointment. Yes. Okay. Well, I would like to thank you, Milena, for sparing your time and coming here, especially before the long weekend. And we'd like to thank you really from the bottom of our heart for coming on the show.
Oh, thank you so much. Thank you so much for having me. I love this.
Thank you.